Classified as a first offender. Offense is second-degree murder. Sentencing date is September 8, 1994. Sentenced to natural life. On October 6, 2020, the trial court granted the defendant's motion to enforce Act 99, making the defendant eligible for parole. Parole date is September 11, 2018. Good time is none. Full term is life. Is this information correct, sir?
Yes, it is.
Mr. Wise.
Okay, Mr. Terrance, during the time you're incarcerated, how long have you been incarcerated?
27 years and several months.
When's the last time you came before the board, or you ever come?
I've never come before the board.
All right, you had a disciplinary write-up back in 17 for 21D.
Yes.
Could you tell the board a little about this?
It was a sex offense with my wife back in March of 2017. A terrible lapse in judgment, one that I deeply regret. It was all my doing. There was no excuses, no faults. I accepted accountability for it. I knocked myself down from the position that I got myself in because that decision was not reflective of the person I had worked so hard to become. Since then, I've done what I've been able to do to make amends with administration and the population to regain the trust that they had once instilled into me.
Are you a trustee now?
I am no longer a trustee, sir. Because of my job requirement, I didn't put back in for it as a healthcare orderly.
Was you a Class A trustee for a while?
Yes, I was.
Back in 2010,
Yes.
You would. It'd been 7 years since you had a write-up, and
Yes,
you got
sir.
this disciplinary write-up.
Yes, sir.
All right. Let me ask you, what is your job at the prison right now? You just told me.
I'm a healthcare orderly assigned to the medical dorm ASH2. I provide services to the guys that need the medically infirm. It's a 24-hour occupation. I live in the dorm where I work at.
Do you what programs? I see you've taken some programs, and what was the last programs you taken?
The last program I've taken was the Victims Awareness Experience.
When was that?
That was at the pre-pandemic 2019, I believe. We concluded it.
Just had substance abuse too.
Oh, yes, I did. And I also had substance abuse. Excuse me, I had that during the pandemic, though. I forgot about that.
Okay. Warden Hooper there, is anything you can say to the board, Warden Hooper, on his behalf?
Yeah, I didn't have any write-up since the last time you already noted it. He did get his GED back in 2002. He is a low Tiger score. He's only had a total of 42 write-ups since he's been with the department.
Right. Okay, I don't have any other questions. This time, Mr. Marabella.
I have a couple of questions. Mr. Simon, how old were you at the time this crime?
I was 17 years of age.
Okay. Were drugs or alcohol involved?
Yes, they were.
Tell me a little bit about your drug or alcohol use. When did you start using drugs or alcohol?
Maybe when I was 12, going into my age of 13 years of age.
Okay, what did you start using at 12?
It started out with marijuana. The boom foam, the little alcohol they sell in the corner store, and it gradually increased to the harder drugs. Eventually, I was using heroin and cocaine and swallowing pills.
How long did you use heroin and cocaine? When did you start? About when did you start? This occurred when you were 17. You've been in prison since you were 17. Is that right?
No, I was in prison since I was 17. I started using heroin maybe at the age of 14,
Okay. And how often were you using it?
daily.
So tell me what you mentioned just a second ago. You've taken some substance abuse classes. What have you gotten out of the substance abuse classes that you've taken while you've been in prison?
I realized that my addiction is lifelong, and that me alone, I'll never have the power by myself to overcome it. With my faith in God and surrounding myself with the right people and continuous counseling, which even since I graduated from class, I've always maintained, support groups. I know that. I know it's not something that I can just face and feel like I got it. I'm stronger. It's something that I will live with, the consciousness of my addiction for the rest of my life. And because I know it's going to be a lifelong journey, I know that I always had to surround myself with the support that will help keep me strong and help get me past it.
Mr. Simon, you've answered a lot of the follow-up questions that I would have had about your addiction. You are an addict. You accept that?
Yes, I do.
And a lifelong addict. That's a problem you'll have to face for the rest of your life.
Yes, it is.
You and I both understand and agree that that's a disease. It's not just a choice, it's a disease. It's something that you're going to have to take medicine for. And the medicine is to go to your meetings and to get a support system and make sure that on a daily basis and a regular daily basis, you're ahead of this problem and you never find yourself wanting drugs without having a support system. Is that what I'm hearing you say?
That is true. That is accurate. Yes.
Now, I also heard, and I'm looking at your record, I also heard that you said, I think you said the last classes you took were a while back. It looks like on your record in this year, maybe January of this year, you took Living in Balance. Did you take Living in Balance this year?
Yes, I did. Yes, I did.
Both 1 and 2, right?
Yes.
Tell me what you got out of
Yes, sir.
those classes. Tell me what you got out of those classes.
Living in balance, I don't want to sound cliche and say that the title speaks for itself, but living in balance has taught me just that, a balance. I have to put forth the effort because I know my addiction is going to put forth its effort. That voice that's going to always be in the back of my head, in my ear, whispering, is going to require me to put forth this effort that's of me and those around me to keep that voice small and try to keep it at a whisper. And it's a balance. Every day I wake up and I feel like it's a victory only after I went to sleep and knowing I haven't relapsed. And living in balance enforces that, right? That you alone are never strong enough. God always first, and God gives us paths. He gives us choices and decisions. And that's how you keep that balance. You never want to fall behind. And those are some of the things that living in balance has instilled in me, which is why I love to talk about my past with my drugs, because it's therapy for others and it's therapy for me, because it always helps me to look at who I was and the things I allowed myself to go through because of my drug addiction, to be like, I never want that again, no more than I ever wanted for anyone else.
Mr. Simon, you got your GED. How much education have you had while you've been in prison?
I earned my GED in 2002. Since then, I've acquired a computer programming certification, the IC3. I'm a culinary artist. I'm certified in that. I've acquired 4 or 5 trades through the horticulture, agriculture department. I'm a certified ISA fitness trainer. And those are the ones that I've completed thus far.
Mr. Simon, you're very articulate. It looks like you've worked very hard while you've been in prison. And I'm pleased with the conversation. Thank you very much, sir.
Thank you, sir.
Mr. Chairman, that's all the questions I have.
Okay, thank y'all very much.
Ms. Parole?
Hello. How
Good
you
morning.
doing?
I'm okay. How are you?
All right. Oh, it's afternoon now. Sir, the victim's family, they have a concern that they've stated about possible retaliation on your part, that you might be still out to get them. Speak to that for me.
The only thing I would like to give to the victims is a sense of peace. If I could, I would apologize for the grave offense that I committed against them. Retaliation is for fools, for lack of better words. My favorite scripture in the Bible, God says that, when I was a child, I reasoned like a child and I thought like a child. But when I became a man, I put childish things behind me. Retaliation for my mistake, retaliation for the act that I did would be stupid. I'm a grown man now. I've matured. I'm remorseful for what I put that family through. They've done me no wrong. I could assure them on my very breath that retaliation is never a concern. It was never a thought for me.
Okay, well, that's good to hear. I don't know where they picked it up from, where they got that information from, but that was a concern that was voiced over and over again.
Okay, thank you.
Okay, yes, sir. Now, you said that you started drugs when you were age 12 and you were in a car. What was your beef with the guy that you shot?
The reality, it wasn't a beef. The only beef was inside of my head. It was a perceived threat that didn't exist. I don't blame it on the drugs, because the drugs didn't make me do what I did. Right? Mm-hmm. It was just my own, internal pains, conflicts, and all of those are no excuses. But it wasn't a beef.
Okay.
Hindsight gives you better vision to things, but there was no beef. He was no threat to me.
All right. I appreciate you answering my questions. Thank you. That's all I had, Chairman.
All right. Thank you very much.
I see that there are no further questions. Can we please hear from Andrew Hunley?
Thank you, Andrew Hunley with Louisiana Parole Project. Here today to inform the board that Terrance Simon is a client of Louisiana Parole Project. But also I must admit that I've known Terrance for several years. I knew him back when he was the light heavyweight champion of the Louisiana Institutional Boxing Association. And I know that his participation in that program was a big deal in his life, and in a place where he was able to learn dedication and hard work and teamwork. And I know in conversations that we've recently had, now that he and I are older than we used to be, whenever those days were, I know that he continues to appreciate those opportunities and what they've meant to him. One thing I'd like to say about Terrance is that I know, especially in the cases of juvenile lifers, you may have cases that come before you and you say, at some point, this guy's coming home, and I know the board's looking at the sweet spot. When do we grant this person parole? Is now the right time? Does he need more time? I don't think I'm overstating it whenever I say that for a 45-year-old who went to prison when he was 17 years old, I cannot think of someone who is as introspective and intelligent as Terrance is at this point today. And I firmly believe that the sweet spot in him being released is right now. He has taken advantage of everything that he can do at Angola, and 2 more years, 4 more years, 5 more years is not gonna put him in a better position for release. It's just gonna mean he's older and has less time to spend with his family and earn a living and start a career. While I know the board, considers the write-up in 2017, I can tell you, Parole Project, in our experience, we sort of look at his last 10 years and feel that over those last 10 years is a clear indicator of the type of person he is, with that being the only offense. Terrance has very strong family support. He has a loving wife, and he has beautiful children that are his kids now, that are very dependent on his support. Of course, Parole Project will offer our program to Terrance, and he will be a client with us until we think that he's ready to go to the next step. And then we'll continue to provide case management support to him. I wanted to leave this board with our Parole Project's very sincere opinion that Terrance has done everything that he can do. And if you release him now, he will make a great impact in his community and with his family. Thank you.
Thank you. Now, can we please hear from Chantel Reed Simon, who's the wife?
Good afternoon, everyone. My name is Chantel Reed Simon. I have been married to Terrance Simon for the past 3 years and 5 months. I want to assure the board that Terrance has a huge family support. I have been employed at my job with the Home Depot for the past 16 years as store operations manager. So I have built my career with that company. I will provide a stable and safe home for Terrance. We have resided at our current residence for the last 10 years. So I'm able to provide him with that stability. I am also here financially, spiritually, emotionally. I will proudly stand beside him in his substance abuse classes and meetings. I look forward to being able to help him with that life balance. Terrance will be coming home to also spiritual support. I am here not only with his 2 sons, our 2 sons, but I am also here with his 2 pastors who are here waiting to provide counseling spiritually, also emotionally, and financially, whatever it is that Terrance need aid in to transition into society. We are here to fill in that gap for him. And I come before you humbly asking you to please give him that chance.
Thank you. Now, can we please hear from Norris Henderson?
Yes, good afternoon. Again, my name is Norris Henderson, and I'm looking at, I call him T. Simon, and kind of like I remember first meeting him, it's like how I get to know Terrance is his mother and my wife taught school together. And so they came up to visit, and when my wife introduced me to him, she kind of like gave me a mandate at the same time. It's like, take care of him and keep him out of harm's way. And so he became like my little brother in that instant. And, like I used to always stress to you younger guys that you can serve time or you can let time serve you. And I guess the testament of his record speaks volumes in the sense that he didn't just serve time, he let time serve him. And so, the work that he do, kind of like the analogy I draw from the healthcare worker, is I was a hospice volunteer. And when you're doing that, that means you're doing something on behalf of somebody else. And when I first got into doing that, and the folks told me, this is not a job, this is a calling. Everybody can't do that. And like Terrance said, his job is a 24/7, 365 because he lives in a dormitory with his patients. And so that in itself speaks volumes about that young man who was trying to find his way 27 years ago. I think like Andrew said it succinctly, is that now is the time. This is the sweet spot where he's done all of these things to kind of like prepare himself for this one opportunity. And the thing about opportunity is being able to recognize it when you see it. I think he recognized it, got his life together. And I think this is one of the individuals that this board really can take pride in saying, we've seen a lot of young men come through here, but this guy, and I kind of like reiterate what Ms. Pearl said, and you're very articulate, and that just don't happen being in an environment where the majority of the folks there, the academic level ain't what it's supposed to be. But when you eke out a life for yourself, to kind of like improve yourself and to improve your life, this is the reward. This is the carrot that folks stick out in front of you that you try to attain. I think today, Terrance has earned this opportunity to be sitting in front of the board. And I just hope and pray that the board really consider Terrance for release. So he not only can turn to his wife and his kids, but to his mom, who I know heart is heavy right now, just hoping and praying that her son, her youngest son, is returned to her. So I just, entreat the board to really consider Terrance for release. Thank you.
Thank you. Now, can we please hear from Mr. Simon? A brief statement before the board votes.
Okay. First and foremost, thank y'all for this opportunity. I appreciate it. I hate the circumstances for why we are here. And if it was ever a chance I could, I would change it, but I can't. So what I've learned to do is just to pay it forward, to invest my time and my energy into trying to help others to better their lives, or at the very least, stop them from making worse of their lives. I share my testimony and who I am and what I've been through. I hope it helps someone see, that you can do better. Not blaming the circumstance or the situations, but you can always do better. Not to say it's going to be easy, but it can be done. My everyday goal when I wake up is to try to put a smile on somebody else's face. I receive my greatest joy about what I can do for the next person. That's going to be my lifelong testimony. I hope that the board will see that, by the record is what I've done and it's who I've become. I'm no longer that little kid who came to prison in 1995. I've matured. I'm not a broken man. I'm a real man now. I'm a whole man now. I'm remorseful for everything that I've done, the things we've discussed and the things that only I and God know. I'm rehabilitated and I work every day to just become better at who I am and to become the person that God initially intended me to be. Thank you. That was it.
Thank you. Can we hear from council now?
Thank you. Good afternoon, everyone. Thank you for your attentiveness and thank you for your consideration. As you've heard from everyone here, almost 28 years ago, Terrance entered prison as a confused and angry teenager. And today at 45 years old, he stands here before us figuratively, transformed. He is a compassionate, trustworthy, responsible man. And unlike the judge that had to sentence him 27 years ago and look through a proverbial crystal ball to determine whether or not Terrance was capable of change, you all have the opportunity to look at the change, to see the change in practice. Before Miller versus Alabama or Montgomery versus Louisiana told Terrance that he had an opportunity to be released, he began his journey to rehabilitate himself. He got his GED in 2002. And as Norris said so eloquently, he allowed time to serve him. And through that time, he has dedicated his life to correcting the wrongs, as he said, that we know about and the ones that we don't know about. I want to highlight that Terrance has over 300 certificates since his time at Angola State Penitentiary. He has published 11 books and has one in pre-publication. And I really want to highlight, particularly because of all the hearings that I've had the opportunity to observe today and seeing so many guys who are in the infirmary, I really want to highlight the importance of Terrance's job and the fact that Terrance told you all that he could apply to be a trustee, but because of his job, he's decided to stay there because his job is so important to him. Norris framed the job or categorized the job as a calling, not just a job, but a calling. But those very people that we saw today are some of the very people that Terrance cares for every day, 24 hours through his calling. And that shows him to be compassionate, that shows him to be renewed, and that shows him to be responsible and trustworthy. I also just want to highlight that Terrance has a ton of spiritual and familial support. You see his pastors here, you see his wife here, and there are so many supporters that you do not see that are here watching via the YouTube stream. And they are all aware of Terrance's needs, and they are prepared to stand in the gaps and support him. And so the final thing that I want to highlight that Terrance did not say is that when COVID started and the dorms were placed on lockdown, he volunteered to remain in the infirmary to care for sick individuals at a time when there was no vaccine and we did not know what was happening with the pandemic. Terrance showed his compassion and he showed his ability to care for others by volunteering to remain in his position. And so I proudly stand next to Terrance and with Terrance and humbly ask you to grant his parole. Thank you.
Anyone else have anything to say before we vote? At this time, the board will be voting. I'll start it off today with my case. Today, I've listened to each and every one today. I had a problem with a disciplinary that he had back in 17. He's done a lot of positive things. He's done some great things. I've listened to everybody talk today, but today I'm going to be voting to grant. I'm voting to grant because he has some very good programs. He has low risk. And one of the main things, he has a good family support. And that's what it takes when someone gets out, a good family support. And also that he go to the
I'll eat a sandwich.
parole project.
I'm gonna go see Fred.
And a curfew from 9 p to 6 a.m. At this time, Mr. Marabella.
Thank you, Mr. Chairman. Mr. Simon, as I said to you when I was chatting with you, I was concerned a little bit about substance abuse. It's a concern that I have. For many years, I was a judge and I ran a drug court. And I'm very pleased with where you are and what you've done in your journey in terms of being able to accept your addiction and work hard on trying to remain a recovering addict. As your attorney pointed out, sentencing judges never have a crystal ball. They try to figure out what's a good sentence for a person standing before them. Of course, in your case, it was life. The judge had no choice. But I know as a criminal judge, I would sentence people and I would tell them, you can turn right, you can turn left. You can be a better criminal. You can come out and be a better citizen. You work hard. And if I have anything to do with it, I will go to bat for you when you get an opportunity before the parole board. I'm proud to say that I now sit on the parole board and I can help other judges who have sentenced people who have that same attitude. And you are one of those inmates that I would want to have sentenced and see what you've done. You should be very proud of your accomplishments. I hope you continue to do the things you do. My vote would be to grant with the same conditions as outlined by Mr. Weiss.
Young man, I just ditto what my colleagues have said. Due to the positive warden comments, your outstanding institutional record, the community support, and the low Tiger score. And I do want to say, Mr. Hunley, I've heard him make a lot of presentations, but yours was special today. Yeah, yours was special. So I can tell there was a connection between you two. So my vote is to grant as well. But I'd like to see you do some community service. To not let it be too much on you. I said 2 hours a quarter of community service. Speaking to at-risk youth, helping the pastors in the church dealing with youth. Of course, you can do more, but at least 2 hours a quarter, because you got some things that you can teach those young people. But that is my vote to grant. Best wishes to you, sir.
Okay, if everyone else has voted there today, you've been granted. I want to congratulate you. You've been granted to all the conditions will be applied to the paperwork there, and you'll be able to get them. I want to thank each and every one that came today. Mr. Hunley and Norris, I know y'all stayed in the same place where he did and went through those battles.
Yes. You granted to the
Thank you,
Louisiana
Chairman.
Parole Project. To the Louisiana Parole Project.
Thank you.
Mhm.
Mr. Wise, I believe that is the last case for today. Can you please adjourn?
At this time, the board will be adjourned. The time is 12.
Okay, I think for this hearing to unpack it, we'll just jump straight into the court transcripts. And then we'll go from there. You know, it's always difficult when you don't hear victim opposition. October 29th, 1993, the defendant Derek Bowman Ward and Sylvester Brown went to the home of Kesha with Derek Bowman went to her door and knocked. The victim, Carol Preston and Rashawn arrived. Preston and Bowman, for whom he was looking when no one answered the door, Bowman and the other three left. Bowman was driving the vehicle and Terrance Simmons was sitting in the front passenger side. At the corner, in response to a request from Terrance Simon, Bowman turned the car around. Bowman stopped the car by Preston's car. I have no idea what I'm reading. It's really quite confusing to me. Terrance said something and then began shooting. Preston was struck by 2 bullets. One of the bullets entered his upper back, traveled through his lung, and lodged in his heart. When officers arrived at the scene, they found 4 9mm casings near the victim's body and bullet holes in Preston's car. Rashawn and Keenan testified that no fight or verbal altercation occurred between Bowman and Preston or between Terrance and Preston. However, in his post-arrest statement, which was read to the jury, Bowman stated that Preston and Terrance were fussing. According to Bowman's statement, after he drove off, Terrance Simon pulled a gun from under his shirt and told him to turn back. Fearful that Terrance Simon would shoot him, Bowman complied. Terrance Simon and Preston again began fussing. When Preston ran to his car as if he were going to obtain a gun, Terrance Simon began shooting. Okay. Keenan testified that he did not see Terrance with the gun and that no one knew he had one. Keenan indicated that he could not remember if Bowman had slowed or stopped the car prior to shooting, but admitted that in his statement to the police, he stated that the vehicle was stopped. In the same statement, Keenan told the police that after the shoot stopped, Bowman asked Terrance what was wrong with him. Ward testified that there was no conversation between Bowman except for Simon's instructions of Bowman's to turn the vehicle around. The defendants, Derek and his co-defendant Terrance, were indicted for second-degree murder. On motion of the defendants Bowman, his trial was severed from that of Terrance, so they had separate trials. On December 4th, 1994, the 12-person jury returned a responsive verdict of guilty of manslaughter. On January 10th, 1995, the defendant was sentenced to 30 years at hard labor. So it's interesting that they did manslaughter. They said, well, maybe he thought he was going for a gun, I guess. Simon proceeded to trial and was convicted of second degree. Okay. So that was what Terrance was convicted of. And then because of Act 99, I guess that's why he was allowed to have his next, why he's allowed to get out early, because he was under the age of 18 when this occurred. I don't know. It just seems like a senseless act, right? You know, there's something else. There's like a 2-minute interview from Dateline that Richard found, which is, you know, it's 2 minutes. It's interesting enough. I wanted to share it, but I'm just concerned with Dateline and how they do copyright strikes. And I'm not basing this off any fact. It's just like, do I really want to show something for 2 minutes, then deal with a potential headache? Even though it's not technically copyright, I just have PTSD from dealing with stuff like that. So maybe I'll put the link in the description. And if you want to watch it, you can watch it. Here's a second link. Which Richard shared. 5 inmates serving life for committed juveniles allegedly recently amended statute entitled them to parole eligibility. They filed a petition seeking writ of mandamus directing the Secretary of Department of Public Safety and Corrections to set the parole eligibility dates. After the district court denied the petition, the inmates appealed. So you have here something interesting about them appealing, which is I wonder why they were denied. In the present case, the defendant turned the whoops, I'm on. Let's see where Simon is. Okay. He's mentioned twice. So he joined it, and it's funny that when he filed this appeal, it was I wonder if this is what got him this parole hearing. In the 2020 regular legislative session, the Louisiana legislature passed 2020 Act number 999. I'm glad we're reading this, so whenever we hear about 199, we can reference this. Effective August 1st of 2020, dealing with the parole eligibility for certain incarcerated persons. 1, were serving prison terms. Okay, thanks. We're serving prison terms resulting in incarceration of 25 years or more. 2, were under the age of 18 when they committed the offense. And 3, had met certain other conditions. Act 99 enacted, subject J, which pertinently provides, notwithstanding any provision of law contrary to any person serving a term of imprisonment is the result of a period of incarceration of 25 years or more, and who is under the age of 18 years at the time of the commission of the offense shall be eligible for parole consideration pursuant to the provisions of the subsection, and certain other conditions have been met. On August 12, 2020, Danny Quinton, James Anderson, and Scott filed a petition for writ mandamus directing DPSC to update its records to show plaintiffs were parole eligible and to set the parole eligibility dates pursuant to new enacted subsection J. Plaintiffs alleged they met all requirements of subsection J and were entitled to have their parole eligibility dates set under its provisions. For purposes of this appeal, we accept plaintiff's representation that they have met. Oh, so this is this is where they stated that they were denied to have parole, and then they said, well, wait a minute, we're not. And then it seems that they accepted it, and that's why you had this parole hearing. In response, DPSC argued plaintiffs were not entitled to parole eligibility under new section subsection J. They argued that previously enacted subsection G, blah, 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 enacted of new subsection J, blah, 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 and for parole eligibility for incarcerated persons who, 1, are serving life sentences, 2, I don't get it. Why? Notwithstanding any provisions of law to the contrary, any person serving a sentence of life imprisonment for a conviction of first degree or second degree who is under the age of 18 years of age of the commission of the offense and whose indictment of the offense was prior to August 1st, 2017, shall be eligible for parole consideration pursuant to the provisions of subsection. Judicial determination has been made that the person is entitled to the parole eligibility to the. Why does I feel like? Do I feel like this is redundant? And also, I'm curious, why is it before August 2017? So if you were 17 years old and you committed this crime in September of 2017, you're not eligible? Why does that even? Did brains start to form faster in September of 2017? Anyways, I think the whole idea that 17-year-old, it's like, we've seen plenty of victims come up here and say, it was 1 week before he turned 18. And really, the guy who, killed 3 people in cold blood is going to now get an opportunity for parole because of this new statute. And it's true. It's nuts. But the problem whenever they pass these laws, it just opens up so many problems. It always creates problems. I don't know. I won't go through all of this. Overall, this hearing was kind of just not that exciting. I'm sorry about it. But we'll play it anyways. It is still interesting how someone, I think he did do everything he needed to do to change his life around, and we got to give credit where credit's due. We have seen plenty of hearings. It's not a given. He didn't know he was going to get out, and people can make different choices once they're locked up, and he made the choices to do everything he can for himself. And I think he should get credit for that and rewarded for it. And this hearing took place in June 2021, and he's stayed out of trouble. He's still doing good, so we got to give him credit. With that, I'll let you go.
3. Sentenced to life imprisonment at hard labor without benefit of probation or suspension of sentence. Parole date is September 21st, 2017. Good time is none. Full term is life. Is this information correct, sir?
Yes, ma'am.
Mr. Wise?
Mr. Powell, I want you to be able to slide the mic up there a little closer or something, speak a little louder, because it was real weak where we was hearing it over here. Okay? Okay, can you hear me good now?
Yes, sir.
Okay, that's a lot better. We can hear you. Can you hear him pretty good, Mr. Marabella? Ms. Pearl?
Yes, I can hear him well.
Yes, sir, I can hear well.
Okay. All right. Mr. Willie, during the time of your incarceration, you were incarcerated. You've been incarcerated. You were sentenced in 1993. Is that correct?
Yes, sir.
And then you got resentenced in 2016. Can you tell the board a little about that?
I got resentenced under the new Act 277. The Act for juvenile life was eligible for parole from the United States Supreme Court from Henry Montgomery. That made me parole eligibility after 25 years.
Okay. All right. Thank you. During this time of your incarceration, I see you've done a lot of programs. What was one of the programs you think it meant the most to you?
The most important program with me was victim awareness, because it gave me the opportunity to see the bad decision that I made and the families that I hurted. I didn't know nothing about victim awareness because on the Louisiana statute, we couldn't obtain conversation with the victims, and they gave me a lot of influence to know about victim awareness, from the primary victim to the secondary victim to the territorial victim. And it gave me a lot of insight on how much trauma they go through for making my bad decision that I regret for the rest of my life.
Okay, can you tell the board, where do you work at there at the prison? Where's your drop at where you work at?
I work at the industrial compound as a compound, but I'm also a tractor driver. I drive tractor, zero turn, box trucks, and I'll work on special details when the prison needs someone to go on the outside gate. And I also was a part of a voluntary COVID-19 group that worked for a whole year while the prison was on lockdown to take control, to help the prison get everything straight while some of the offenders was locked down. We took over their jobs for a whole year and 2 months.
Okay, let me ask you something. And back in I guess it'd be July 25th of 05, you had a 30. And then you hadn't had a write-up from 05 until 2016. And I see you had a write-up on 10/9/16 and 10/9/16. Tell me about that.
I made a bad decision. I allowed my friends to get involved, and I got punished for it, and I did what I was supposed to do. I went 5 years since that incident without a write-up, and I took full responsibility of it.
Yes, okay. Well, I see that there was no one lost any, you had no write-up since the last hearing.
No,
Well, I
sir.
commend you on that. It's been a while since you had it. During this time where you're working at, how long have you been a trustee there at the compound?
I've been 10 years, then I lost it, and I got it back in a year. I've been out for Class A now for 4 years and a few months. So altogether, 14 years and 6 months.
How old were you when you first came in the system?
18 when I got there, Angola. I was 17 when I got locked up.
You were 17 years old.
Yes, sir.
And you came in here in 90 something. That was a big change from the streets, wasn't it?
Yes, sir. Very big.
As I look on there, I see you've got your 100 hours pre-release, your anger management, cage and raise, living in balance, 1 and 2, victim awareness, thinking for a change. You've done all those programs.
Yes, sir.
And if you were to get released, where would you like to live, and where would you go if you were released?
If I'm granted mercy from the board, my first stop would be the Louisiana Parole Project. I would be there until they see I'm suited fit to go to society. Then I would be going to Baton Rouge, Louisiana, to stay with my fiance, who has a job and transportation for me if I be granted mercy from the board.
Okay.
He also got.
All right.
a in 99.
Warden Booker, is anything you'd like to say? If y'all would put the camera on Warden Booker.
He also did receive his GED in 99 as well. Like you said, he hadn't had any write-ups since 2016. He works. He's a Class A trustee at Angola. Not having any issues with him.
Okay. Thank y'all very much. At this time, Miss Pearl Wise.
Good morning.
Good morning, ma'am.
Call out for us some of the trades that you've had a chance to take while you've been in Angola.
I'm a certified concrete finisher. I have
Carpentry.
Carpentry. I also have what they call fiber optics. I took a course in that, and that's 3 of the trades that I have.
And paralegal studies also, right? You completed that.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Okay. I know you're nervous. You're nervous. Now tell me about this. It was in the record that that you were, of course, it was pre-COVID. You was going to church 4 times a week.
Yes, ma'am. On my denial from last time, I went before all the churches that I've attend, and I gave my speech. I told them that don't let it be on you when you go on the parole board. I made a bad decision. I took accountability of it, and I just let them know that, you know, you get a second chance, but when you get your second chance, make sure it's the right thing that you do and that you get everything in order so it won't be on you if you get denied.
Yeah, that's true. It won't be on you. That's wise advice. All right. And you do know that you do have some victim opposition that's been expressed.
Yes, ma'am.
I don't want to really go into the offense, but both of your co-defendants have been released. Is that correct?
Yes, ma'am.
Okay. Do you know how they're doing?
They're doing all right. They're doing all right. They got a good support family system behind them. Both of them are working. They just stay in different parts of the state. Okay. Okay. All right. That's all I had. Thank you for answering my questions.
Thank you, ma'am. Mr. Marabella.
I don't have any questions. Thank you, Mr. Chairman.
There are no further questions at this time. Can we please hear from Andrew Hunley?
Andrew Hunley with Louisiana Parole Project. We represented Willie at his 2018 parole hearing, and we continue to stand by his side. I'm going to be as brief as I can be because I know there are several people who want to talk, but a couple things I want to point out is one, as Willie said, since his 2018 parole hearing, he did not sulk, he did not backtrack. He completed several programs since that hearing, which really impressed us, from thinking for a change, victim awareness, and concrete finishing. So we feel like that Willie is even better prepared for release than he was a few years ago. Would like to also mention that Willie's reentry plan has him going nowhere back to the area where his crime was committed. He will be staying with Parole Project in the Baton Rouge area, and then will make his long-term residence in Baton Rouge, where we will continue to provide him case management and peer mentorship services in the long run. It was asked earlier about his co-defendants. One of his other co-defendants was a juvenile lifer, Frederick, who was released to us over a year ago. And Frederick has been home for over a year and is doing exceptionally well, working, rebuilding his life. We have no doubt that Willie, if given the opportunity, will reintegrate successfully, and our organization stands by to provide those services to help him with his reentry. Thank you.
Thank you. Can we now hear from Carmenisha Hill, who's the fiance?
Good morning. I'm truly thankful and elated to come before the Louisiana Parole Board as Willie's fiance with great love and support for his upcoming future once he's granted parole on this wonderful day. Since Willie and I have met, he's been an asset to my family, my son. He is my son Caleb Hill's #1 supporter. He has assisted me and told me what to go to buy to the store when Caleb has had groin and injuries on the team. He's also speaks to my son about grades, behavior, peer pressure. He's been a great asset to my son maturing through his teenage years. Willie will be provided with safe and comfortable home with me and my son in Baton Rouge with transportation and enormous support. I have secured a job for Willie with the Luster Company and Properties, and Mr. Luster has called twice since Willie's last parole hearing, finding out when will he be released because he has a job waiting on him. I also have great support system from my coworkers, my church members, my friends and relatives that are here to assist and help Willie back into the real world. They have all purchased clothing and different items, and they're waiting at my house. In addition, Willie will continue to work with the Luster Company. And in 2022, when the year comes in, he will possibly start truck driving school. I've talked with someone because his main passion is to be a truck driver. In addition, Willie's parents and family members have never left his side. They have been with him mentally, financially, and all of his time of incarceration. That's why it was imperative for me to drive here to Shreveport, Louisiana, and be surrounded by his mother and father, his aunts and uncles. We have about 20 people in here and many people watching. Even though Willie will be staying with me in Baton Rouge, his family has no problem traveling to Baton Rouge to be with us. As we're here today, I truly believe God spared Willie's life and set him down in a place like Angola. He has an excellent work history. He also has many attributes. He is even desired. He wants to help the youth. We have started we're in the process of starting a nonprofit. We shoot hoop not guns, and that was Willie's idea. And the website has been started, and I'm working with someone to get us the 501c3 paperwork. So Willie has great support. We are ready and we're willing to assist him back into society. He has great admiration and he is really remorseful. But since I met Willie, his first priority was to get to know his family, and I've got to know them. I love them. I travel to Shreveport a lot. And it's like I say, it was very imperative I come here today to be with them and they be with me. We've prayed and fasted for such a day like this. Upon Willie being granted parole today, I'm ready to support him and hold him accountable. As we close, I must add that Willie has proclaimed his mental freedom long before he knew the chance of parole would come. And he said, I vow to never let a place like Angola mentally bind me up. So I'm free mentally, and I pray that I can be physically free.
Ms.
And on
Hill,
that-
please pick it up. We have other
Okay,
people who need to
no,
speak.
And on that note, I am willing to assist Willie, and we pray that you grant him physical freedom today.
Thank you. Can we please hear from Norris Henderson, who's a friend?
Good morning, everybody. I think Andrew really capsulized what I would say for Willie. The only difference is that Willie was one of my ball players, and so I really had a lot of close contact with Willie to watch him, see him grow and develop into the young man that I say young man because he's like 20 years younger than me, but I say young man because he's really matured. And I mean, really, really matured as the young guy who walked on the football field over 35 years ago saying, I know how to play ball. And, you know, I heard that from a lot of guys that know how to play ball, but Willie really know how to play ball. And so I was just really excited just now when his wife was saying about the opportunity in the program that Willie wanted to start. And I'm here to kind of let the board know that I will be there to help Willie every step of the way. We have a chapter in Baton Rouge. That's, matter of fact, rent space in the same building that the Parole project is in. We're on 2 separate floors in Baton Rouge. And so anything that the Parole project may be lacking to offer to Willie, that between the first 72 and vote, we got his slack. And so I appreciate the board today really considering Willie for release. Thank you.
Thank you. Now, can we please hear from John Watkins, who's a cousin?
Good morning. I'm speaking today to request that Willie be granted parole. I had the privilege of visiting 2.5 years ago, and to hear other inmates, as well as Angola staff, speak so highly of Willie's character and how athletic he is, just remind me the moral foundation that was instilled in him by his parents and enforced by his surrounding family members. As you already know, Willie has secured a job and has a place to stay after his release. That, coupled with the family and friend support system that's awaiting his release, I believe that he can be the law-abiding, productive citizen we know he can be. We as a family are prepared and ready to assist Willie acclimation to society by attending church with him and helping him adapt to the many changes that have occurred since he's been incarcerated. We hope and pray that you find in your heart to return Willie back to us, and as we prepare our roles as to supporting him. Thank you.
Thank you. Okay, we will now hear from opposition. Can we please hear from Ms. Rennie Potter, who is the victim's wife?
My name's Rennie Potter, and I am the widow of the victim, Steve Potter. Steve Potter was my high school sweetheart, my husband of 18 years, and the father of our 2 children. Our children were 7 and 9 when their dad went to dump yard waste and household trash at a nearby trash compactor and never came home. His lifeless body was found in a remote location the next day. Willie Plater is one of the 3 young men charged and convicted in my husband's death. By all accounts, Willie was raised in a good home with a mother and father, and he grew up surrounded by an extended family and attended church. He also attended high school and played sports. I just can't comprehend how someone of his background thought it was the right thing to do. He wanted a joyride in a car. They were tired of staying at home. And he and his friends left a family reunion, walked down the road towards the trash compactor, discussing the carjacking and who they were going to shoot to get a car for a joyride. And I can't possibly understand how you go. I mean, I grew up on a farm in a rural area. We had the bare necessities and little else. I too felt isolated as a teenager. I dreamed of the freedom that a car would give me to get off the farm, to see friends, to do things I wanted to do. It never crossed my mind to rob someone, to steal a car, to shoot someone, to get their car, to take a joyride, to do something I wanted to do. I just can't comprehend this crime still to this day. Something was missing. And I believe that his decision-making is flawed. So I respectfully request that his request for parole be denied. My daughter is attending today. She has written a short statement. She, to this day, cannot speak of the loss of her father and the impact it has had on her life. So she has asked me to read her statement. And she writes, please do not grant Willy Plater parole. At 17 years old, he helped murder my father and then threw him away like trash. I have wished and wished that Willy would have talked some sense into the others that planned my father's murder with him. I wish he had talked them out of it. I wish he had suggested that they just steal the car and leave my father alive. But he didn't. He made a conscious, premeditated decision to help murder a man. Willy destroyed my family and ruined our lives. The pain he has caused is beyond measure and is never ceasing. Every year that goes by, there are a million things that I wish I could share with my father, but he is not here. He has never met my husband or his 3 grandchildren. Willy does not deserve a second chance at life because there is no second chance for Steve Potter. If you release Willy, his family will be so overjoyed for his return. But what are we left with? Is there anyone returning home to us? No, Steve Potter will not be returning home to us. He will still be dead and buried. Let's see.
Thank you. Now, can we please hear from Sandra Potter, who's the victim's sister?
Good morning. My name is Sandra Potter, and Steve Potter was my older brother. Thank you to the Louisiana Board of Pardons, Patrol, and Parole for the opportunity to ask you to deny parole for Willy Plater. As you have heard, my brother was murdered by Willy Plater and Fred Thompson on September 20th, 1992. I've read the statements that Plater gave to the authorities back in those days. He made bad choices on that fateful day, and he didn't have any remorse for his actions. My brother was murdered in cold blood and his body dumped in the woods for a car. My family has greatly missed Steve for the last 28 years, 9 months, and a few days. He was a good son, brother, husband, and father. His death left a hole in our family that cannot be filled. My brother never got that chance to see his kids grow up, escort his daughter at her wedding, celebrate his son's college graduations, and play with his grandchildren. I hope that the parole board has read all the letters and testimony sent by the family and friends of Steve, and they're pleased to deny parole for Plater. We are here because the Supreme Court says that it is cruel and unusual punishment for Plater to spend the rest of his life in jail without the chance for parole. The real cruelty is that while Willie Plater gets a second chance to live, my brother will never have that chance. And if Mr. Plater is given that chance by the parole board, I would like him to remember the grief that he has caused for my family and for his family. And remember, my brother doesn't get a second chance. Again, I ask the board to deny parole for Willie Plater. Thank you for your consideration.
Thank you. Mr. Plater, would you like to make a brief statement before the board votes?
Yes, ma'am. In 1992, I made a bad decision that I will regret for the rest of my life. It's not a day that goes by that I don't think about the decision that I made. It's not a word in the dictionary can show the remorse that I feel for the victim's family that I caused grief to. But I'm not that individual anymore. I have changed, I have matured, I have educated myself, I have provided myself with the right people around me that led me to become the man that I am. And if I'm giving scepter to the board, I throw my mercy to the board. If I'm granting mercy, I would never, as long as I live, forget the bad decision that I made. But I will be a better citizen if I'm granted parole. I just like to thank y'all for this opportunity, and God have mercy on my soul.
Counsel?
Thank you. Because Mr. Plater was convicted as a principal to murder when he was 17 years old, the relevant inquiry in this parole hearing is whether he has demonstrated maturity and rehabilitation throughout his incarceration sufficient to warrant an opportunity for release. What's really remarkable about Mr. Plater's institutional record is long before Miller, Montgomery, or any Supreme Court decision, he began showing signs of rehabilitation almost upon entry. He received a GED in 1999. His list of accolades is extensive. There's also numerous faith-based certificates that weren't mentioned. Any opportunity for education, self-help programs, or faith-based, Willie has thrown himself into them full force. He's participated in sports. He's coached other people. He's done what he could to make not just himself a better person, but to turn around and to share positivity with other people that he's incarcerated with. Since his last hearing, he completed Victims Awareness Thinking for a Change, and as he stated, he volunteered to work on a stick-out crew throughout the COVID-19 pandemic to help the prison run more efficiently. All of this demonstrates that Willie Plater is rehabilitated. He is not the individual. His crime was not so indicative of permanent incorrigibility that he should spend the rest of his life in prison. And so we would ask this board to recognize his demonstrated maturity and rehabilitation over the last 28 years of his incarceration, and to grant him an opportunity for release, to release him to the parole project with any conditions that the board deems appropriate. Thank you.
Okay, at this time, I'd like to call for an executive session.
I second.
Okay, thank you.
Ms. Parole?
Yes.
Mr. Marabella?
Yes.
Mr. Wise?
Yes. Board will be voting at this time, Mr. McKay. At this time, Mrs. Pearl Wise will be voting.
There's no mistake that this is a difficult decision. We have letters of support, multiple letters of support on both sides, from the opposition as well as those who are in favor. As already been stated, the Supreme Court, reason why we're here, but the Supreme Court said if they have demonstrated maturity, they have an opportunity for parole release. Mr. Plater, you've demonstrated maturity. You have a low title score. You have good programs. Like you said, you volunteered during the COVID time. I mean, when the chips are down, you stepped up. That speaks volumes to me, especially during that time. I mean, it was truly a life or death situation. We didn't know. We didn't know as much about it. There was no vaccine at the time. So my vote is to grant, and that you be granted to the Louisiana Parole Project, as you stated, and I concur, for a sufficient amount of time to complete the programming that they find appropriate for you before you transition, to another situation, transition out of the Louisiana Parole Project. And again, it's due to your outstanding transition plan. You have a low tiger, the outstanding programs that you participated in. That is my vote, and the family support that you have that's been expressed here today. That is my vote.
Mr. Marabella?
Thank you, Mr. Chairman. Mr. Plater, I've listened to everything here, and as Ms. Wise pointed out, this is an extremely difficult case. I hear very clearly what the victim's family says, and I understand their grief, I understand their pain, and everything that they have said today is true. We are here, however, our role and our responsibility, according to the law in the Supreme Court, is to look and see what you have done and who you have become since you committed this horrible crime when you were 17 years old. And while it's critical to me to hear the victims and the victim's family, my responsibility has to take in all of the factors. And in taking in all of the factors, the things that you've done, you've been on for parole, you've been denied, you've been told what to do, how to do it, when to do it, and you've done those things. You began to do those things before you even knew you had a possibility for parole. As hard a decision as this is, and as hard a decision as this is for the victim's family to hear, my vote today will be the same as Ms. Wise, to grant grant relief as requested. That would be my vote, Mr. Chairman.
Okay, thank you very much. At this time, I'm going to concur with my colleague. You were a juvenile lifer. One of the things I had a little problem with, I knew you had the disciplinary write-up back in 16. You came before the board in 18. You was denied on that charge. And you've done very well since then. And today, my vote is going to be to grant to the Louisiana Parole Project. Also, when you get out, you are to have a curfew from 6 p. From 9 p to 6 a. Curfew. And good luck, and I want to thank each and every one for being here today. Thank you.
Thank you, sir.
Okay, so we're going to go over the records that Richard found on this case. But before we do that, I just want to vent a little bit. One is, maybe, Richard, I think we need to stop doing parole hearings where it's Miss Wise and Jim Wise that are doing the interviews, because I just can't. I can't do it anymore. I keep pushing it off, but when I see that the panel is made up of Jim Wise and Miss Wise, and they're conducting the interviews, we get nothing. Miss Wise actually used the words, I don't want to get into your crime. But your co-defendants, they're out. How are they doing? Oh, they're doing great. That's great. We have to listen then to his three supporters. And these supporters, they ramble and they ramble. And we always see this. It's like, do you have any sensitivity that the victims are watching this? That the wife, that the daughter are watching this? The things that they talk about, it's insulting. The first supporter, we're working with someone to give us paperwork to open up a non-for-profit. So basically, you don't even have the paperwork yet. That's great. I'm so happy that you're working with someone to give you paperwork. Then the next one, he was a great football player. When we were in Angola together 20 years ago, I'm telling you, he could play football. It's like, what are you guys saying? And it's just rambling and rambling. And then you come down to the difference. And all of a sudden you hear his wife speak, the high school sweetheart. And that's when you feel real emotion. That's when you hear real pain. That's when you hear substance. But no, Miss Wise doesn't want to get into the crime. That would be too I don't know, serious to actually ask him why it is that he felt like he should just kill a man for his car. You don't think it's important to hear what he says, to hear the story he says? Just a disturbing interview the whole way around. Oh, let's hear about your programs. You've done some great programs. Shame on you, really. And there's all this celebrating at the end. Again, complete disregard for the victims. Can you imagine these victims had to watch each one of these each one of these people who took their father and took the husband, took their son, took everyone, to see them all get out of prison through parole hearings like this, while they all laugh and clap and talk about what an athlete he was. Well, they're left there alone, to be alone. No assistant DA there, nothing. It's just them. The daughter still can't even speak. She has to have her mother read the letter. How do you think she feels about the justice system? What kind of lasting effect do you think this has on her? Here's the newspaper Richard found. This one. Three men accused of the September 20th murder, I'm going to say it, Shreveport, of the geologist, Stephen John Potter, sat silently in Cato District Court Tuesday as their own words convinced the judge to hold him in jail without bail pending formal indictment on first degree. The defendant, Willie Charles Platter, Joseph B., and blah, blah, blah. From the transcript of Platter, the afternoon of Potter's death. But Fred, the one that decided and everything, he come up behind and popped him in the head. Lunsford read not once, but several times. Lunsford said Platters commented about a discussion the three defendants had before the shooting when they were discussing ways of getting a car. Lunsford, who had been recollecting statements taken during the interview with the defendant September 21st, referred to the transcript under prodding of Plater's defense counsel. Potter, 38 years old, was shot once in the back of the head while taking trash to a compactor on the Norris Ferry Road not far from his home. Investigators said he was killed and his body dumped off the Robinside Road south of Shreveport by teens looking for a car to steal. He's a great football player, everybody. Let's make sure everyone knows that. Friends and relatives of the victim, including the widow, sat in the front row of the seats, spectators gallery, watching as first Cato Parish District Attorney Paul Kermouche and then the three defense counsels grilled Lunsford. The detective was asked about the circumstances of Potter's death, what statement the defendants made, and how Thompson said he came into possession of Potter's car. Mrs. Potter would not comment after the hearing. Lunsford said Thompson implicated Platter on Collins in a statement and that Platter and Thompson's each identified the other as the gunman. Platter and Thompson each identified the other as the gunman. Well, that's something you could have asked at this parole hearing. Who was the gunman? Who shot him? Each said that Collins ran away when the shot was fired. The three defendants, all 17, and Captain Shreva High School students faced the death penalty or life in prison. A tentative arraignment date was set Friday, pending an indictment of 3 Cato Parish jury meetings. What a disgrace of a parole hearing. A complete disgrace. They get life in prison, then they make amendments to the law. They get this parole hearing, and they don't even have the decency to ask what happened. On September 20, no, let's just talk about your programs in football and the non-for-profit that you're working on getting the paperwork for. On September 20, 1992, as Stephen Potter's unloaded trash from his vehicle parked near a dumpster in Cato, he sustained a gunshot wound to the back of the head. 2 days later, authorities arrested the teenager who was still driving the victim's car. Subsequent investigation resulted in the defendants, Willy P Jr. and the individual also being taken into custody. In response to an indictment for first degree, a unanimous jury convicted Peter of second degree. Thereafter, the trial court ordered the defendant incarcerated for mandatory life imprisonment of hard labor without parole, probation, suspension of sentence. We know how that went. He now appeals, relying on 14 of his original designated 26 assignment of errors. So his appeal does have a few interesting points. Not that I think should have made a difference, but the one that I'll bring up that I thought was pretty like classic Louisiana was that he was shackled during his trial. And I think for us law nerds, could you imagine someone being shackled at a jury trial? I mean, that's just like a plain no-no, but he was shackled during his jury trial. So he was in leg shackles. And so they appealed saying, hello, you can't do that. And I can read it, but in short, they said, should I just read it? The trial judge and denial of the motion for mistrial would not be disturbed on appeal, absent of abuse of discretion, blah, blah, blah. They do bring up references where I guess it's happened in other places. And measure should be ordered only where the prejudice suffered by the defendant has been so substantial as to deprive him of any reasonable expectation of a fair trial. And again, I mean, come on. This is absent exceptional circumstances. A defendant before the court should not be shackled, handcuffed, or garbed in any manner destructive of the presumption of innocence or detrimental to the dignity and partiality of the judicial proceedings. And that apparently was rolled in 1982. Even so, for finding a reversible error, the record must show abuse of the trial court's reasonable discretion resulting in clear prejudice of the accused. So we agree that the record disclosed no reason for having Plater bound during trial. In respect, the district judge errors. So they admit that the judge was wrong. Nonetheless, the lower court observed that the defendant's leg shackles could not be seen if he kept his feet under the table. Although defense counsel speculates that the manacles, cuffs, might have been noticed as Venner members approached the bench seeking to be excused from jury service. The record contains no showing that the effect, nor any evidence that the exposure sought prejudice of jurors. Instead, desired to select the panel stated ability to Plater's innocence. Here is the trial court appropriately denied for the mistrial. These two assignments do not present reversible error. So I would just call BS on that. It's more like, yeah, the judge made a mistake, but nah, you're not getting a new trial. They're like, he could have put his feet under. And because of that, it's like, dude, you have leg shackles. I mean, they're going to hear every time you shuffle your feet, these metal chains. You don't think they're going to wonder what that is? You don't think that maybe they're going to see it, for any reason? It's like, come on. But I'm not saying he should have gotten a new trial, but it is pretty mind-blowing to me that a judge wouldn't know and understand that and do everything in their power to not get a mistrial, especially in a potential death penalty case. I don't know. Things were different back then. Testimony by the victim's wife challenges that. At its first witness, the prosecution called the wife of the murdered victim. We heard her. Before she even took the stand, the defendant leveled a relevancy objection, asserting that the only possible purpose of her testimony would be to create sympathy in the minds of the jurors. The court overruled the objection and denied the subsequent mistrial motion, grounded on the same contention as his 20th and 21st assignment of error. Complained of both rulings. Evidence is relevant, intending to show the fact of the consequence of the termination. It is interesting as to why she would testify. I do get why they would object to her testifying, but only Mrs. Parter could establish the victim's presence near the time of the homicide. Okay. At the same dumpster where Plater admitted concurrently participating in the armed robbery. Thus, her testimony served as a basis for the state's theory that her husband had been killed at that location, dragged to his car, and his body later abandoned on another site. Further, the witnesses explained how the crime and investigation began and also identified the clothing found in the trunk or stolen car not to belong to her spouse. Although the witnesses may have cried on the stand and related without contemporaneous objection how her children waited for their father to return and tucked them in bed. I can't. I'm sorry, I'm getting emotional, but you cannot just take the life of a father because you want his car. And remember, this is done in the 90s. He doesn't have a cell phone. You could do anything. As she was stating, you could have done anything. You could have simply taken his car. You could have gone on your little joyride. No, you had to shoot him. You thought that would get you an extra day, an extra 2 days. What are you getting? It's the same thing if he's dead or alive. They're going to be looking for the car. There's going to be a bolo out for the car. The whole thing is madness. Someone who thinks that way can't. I don't know how many programs you have, but there's something really wrong with you. How does it just get excused? This isn't the typical type. We've seen a lot of different cases where I say, it's understandable how it could have happened. It was a crime of passion. It was a crime of anger. It was, gang related. It was something where it was armed robbery that went wrong, so to speak. Like, there are different things where it's like you can at least, but this is it's just completely senseless. And these type of crimes should be viewed differently, because if you can't understand the wiring of someone's brain, oh no, but he was 17. See, he didn't have a fully developed frontal lobe. Oh, right. If he was 18, then no, but 17. I don't know, man. I would say, I know he did serve a long time, but it's just the way this whole hearing was handled is just disturbing, in my opinion. I can't do it anymore, Richard. We got to stop for the Jim Wise, Miss Wise. I mean, we can mark them, but I'll only do them like when I'm in the right headspace. With that, I'll let you go.